Hello and Assalamu alaikum. My name is Mohammed Asad and this is my fellow intern Mohammed Zafar. We are currently interning at Courting the Law, and today we are going to be interviewing Mr. Abrar Hassan, who is a famed lawyer. He has completed his LLB and his JD. He has served as the president of the Bar Association, and he has been an advocate of the High Court and of the Supreme Court, and has had more than 33 years of experience.
Firstly, sir, in the civil litigation, like what are the three main attributes or qualities of a lawyer to be successful in this?
Well, civil litigation, in fact, is a very cumbersome procedure. It is governed by Civil Procedure Code. Now, in civil litigation, what happens in our society is that a party who has done wrong tries to protect the proceedings. A party who has the right to the property or to the claim suffers from protection. Why? The question is why. Number one, there is cumbersome procedure for the service on the parties. Very cumbersome procedure. You have to get, service summons or notices served first before you are heard. Number two, there are interim reliefs which are provided at the time when you file a suit. Interim relief, if you succeed in obtaining interim relief, and if the party whom you are representing is not so honest, then of course you can protect the proceedings. So this is number two. Number three, there is a concept of interrogatories in our Civil Procedure Code. It is a very good procedure which is provided in all civilized societies. For example, in USA, interrogatories are completed in the offices of attorneys. The witnesses are examined and cross-examined, and interrogatories are completed. So it will hasten the procedure. It will simplify the procedure. But here, usually, advocates do not follow the procedure given in the interrogatory section of the Civil Procedure Code. This is also very important thing. Then we have a provision in the Civil Procedure Code which says that before the issues are framed, the parties may be called by the judge, either in his chamber or in the open court. And there should be an attempt to persuade them to come to terms with each other. But this procedure is not followed strictly by the courts here, civil courts. So these are the procedural rigmarole due to which there is delay in the disposal of cases. And last of all, we do not have the assistance, our judges do not have the assistance of research officers. In USA, in the Superior Court of in Georgia, where I did my internship, you see the judges had one judge had up to 6 research officers, students. They were good students, and they used to come and voluntarily do the research for the judge as to what is the problem and what is the issue and whether this issue has been settled earlier, because it is a common law country. Pakistan is also a common law country. It is an issue which was earlier decided by the court, and this is the judgment. Judges don't have so much time, and if the research work is done by the assistance of good students of law or junior advocates, then of course the writing of judgment and the writing of decision can be expedited. So these are the things which if followed, and I'm now trying to, you see, India has amended, because we also inherited the same civil procedure code as India did.
The Amendment Act 2002.
Yeah, they have amended civil procedure. We also, at least in keeping with Indian amendments, we should also amend. So I am trying to write something on this and to give it to the Honorable Chief Justice.
Okay, thank you, sir. So, my next question is that we see that the upcoming law graduates, like when they enter the legal profession from the textbooks to the practical work, so they suffer difficulties and complexities in understanding the legal procedures. Sir, how should they encounter these problems?
Well, I think number one, there should be proper guidance from their seniors.
Yes.
That guidance is not provided by the seniors. That guidance is not imparted, teaching is not imparted to the junior student. The need is that after doing graduation, law graduation, and after joining the profession, if some junior advocate is attached with the senior should guide him properly. Now, in our society at least, we know that there is a lot of corruption.
True.
The junior advocates, if they, you see, are involved somehow in the corruption from the very beginning, then they are going to be, not to be good advocates, they are going to be good criminals. I may tell you. And this is very bad in our profession. That junior who steps into the office of a senior start thinking that he should have the same income as the senior has, he should have the same amenities as the senior has, he should have the same model of car as the senior, he should have the same bungalow. You see, he does not realize that a senior has done it after practicing about half a century or 30 or 40 years. So the greed, there is no good coaching, I tell you. And therefore I have written a book. It is a monograph. Rahul must have told you.
Yes.
This gives the procedure to the beginners. What is the procedure in sin? What is the procedure in the what is the judicial procedure prevalent in the province of sin? And what are the ethics? Well, we have canons of ethics and conduct for the advocates and for the judges also, for the lawyers and for the judges. But nobody even, you see, reads those provisions.
So reading is the main problem, I guess.
Main problem. And the junior thinks that once he steps, and the seniors are to be blamed for this. They do not teach him properly. So after completing 6 months training, he becomes a lawyer, independent lawyer. He can do anything. He can file any case. He can, you see, compromise any case. This is the thing. Number 3.
So the next question is that some of our students get involved in internships doing their first year, second year, and third year, so they have to do it. So I want to know that are internships really important for us?
It is very important. It is very important because it is the first step to the joining of legal profession. It is the first step on the staircase of the success of a lawyer. So internship is very good. Here we call it pupillage. And it is mandatory 6 months pupillage. After doing LLB and at the time of joining the bar council as a member, you should have completed 6 months pupillage with the senior. And the senior should be really a senior having practiced about 10 years or more. So this is very important step.
So my next question is that in our judicial system, what are those key issues which are delaying justice? Because as Lord Denning says, justice delayed is justice denied. So what are those key issues in our system?
But there is another aspect. Justice hurried is justice buried. You see, in fact, I have already answered this against the first question. What are the reasons for delay? Under Civil Procedure Code, the reasons of delay have been explained by me.
Yes, sir.
And under Criminal Procedure Code, you know that there is rampant corruption in our society. What happens? Take the example of Hudud ordinance. It is a very strict law. Okay? It is very strict law. And very strict punishment provided. But what happens? That once a FIR is lodged and a person is hauled up in Hudud ordinance, then he, in collusion with the police and investigating officers, tries to lengthen the proceedings. And the advocate, the lawyer who is engaged, is also involved in this, lengthening the proceedings. Tries to win over the witnesses. And witnesses, you see, as you know, the procedure in Criminal Procedure Code is that if you examine the witness, it is under section 161. The IO examines the witness in a case, particular case. And if an accused pleads guilty, he is also taken to be examined before first class magistrate under section 164 CRP. But then, when they appear in court, they resign. They are declared hostile. At least those who have been examined under section 161, they are declared hostile. So, this is due to corruption. If a case is proceeded day to day, as is in USA or in England, a jury called will not be terminated or will be not be sent to their houses till the case is heard. See, that is the, in our society, in our cases, in our procedure, there is no jury, and the result is that it depends on the judge, and moreover it depends on the conduct of the prosecution and the IO. Either the witnesses are won over, or the witnesses, if so much delay is caused that the witnesses move from one place to another, they cannot be traced. That is the failure. Next.
Sir, so when students are usually graduating after completing their LLB, so one common confusion that they have is whether they should pursue their bar or should they pursue an LLM. So in your experience, what would you advise them? Like, when's the correct time to give your bar or LLM? Is it immediately after you graduate, or do you take a few years to practice, or anything that you might?
It depends on the resources. If you have the resources to go to England and do bar, you can do that. But if you don't have the resources, you can do your LLM from here, masters from here. In any case, you see, much depends on the outlook, attitude, and the perception of the individual student. How he proceeds in his career as a lawyer, that is very important. Many successful lawyers, they did not do any bar, or they did not do any JD, or did not do anything outside, but they are very successful because they studied, they conducted themselves properly, and they, you see, the most important thing is the greed. In this profession, this is not a profession for minting money. This is not a profession, this is not an industry or business. Here, you have to be contented. Whatever fee you receive, you have to be contented. You should not go and you should not express your greed. So therefore, I would say that it depends upon the resources of the people. If they have money and they can go to for 1 year England, and they can have bar examination and they can eat dinners with the lords, then of course they should go after all. But if they don't have money, they don't want to do this, they should start here. But they should start in right earnest. They should not be greedy, or they should not be indolent, or they should not be, you see, they should study properly. They should, because it is basically a common law country. Therefore, a case decided earlier will be followed later. Therefore, you have to study. It is a common law country. When you come across a question, then for the solution you have to go to the law journals and to see whether such a question was decided earlier, in what manner it was decided. So this is it is up to resources of a person. So next.
So my next question is that in the Sindh or in the Punjab, like both graduates are coming, the international LB ones and the local LB ones. The international LB ones have the drawback of not studying the procedures of Pakistan, for example CPC. So what law graduates do you prefer, the international ones or the local ones?
I would prefer a law graduate who has studied the law in England or in Pakistan, or in America, wherever, and he's sincere in his work. It is not necessary to go abroad and take a degree from there. You should devote yourself. A student should devote himself to the study here. I will give you an example. I have 56 years practice. In my practice earlier, I was doing criminal work also. Now I am confined to civil and constitutional matters, but in earlier days, I was doing criminal cases also. A case came to me under section 145 CRPC. My shop was locked. My shop was locked after the FIR was lodged that this is a disputed property, therefore the SHO came and he locked under section 145 CRPC. I had to appear before the magistrate in that case. I read the law, after reading it, I took out about 12 good rulings. And luckily, Mr. Hafiz Pirzada was appearing from the other side. And he also came before the magistrate. See, although he had done his bar and he had recently come from England and he was teaching in Asad Law College. So he was like my Ustad also. And he was against me. And I argued my case. I argued and Hafiz Pirzada was kind enough to concede after my argument. And then he patted me. You did good work. So, it depends on a person. Study, go to England, go to USA, go to Canada, you do go to any place. But if you are not sincere, if you have not studied properly, if you do not want to put in labor in cases, then of course it is useless. Having a degree, nothing.
Sir, my other question is that while you're studying law, so was there any specific person who was your mentor, or you pursued him to be your mentor as a role model?
Well, at that time, there was Mr. Abrar, and he was very fond of youngsters. He used to, whenever he had time, he used to. Then in my building, I used to sit in Bank of India building, that is Courtview building now. There were very famous advocates, Dingumal Ramchandani. They were very famous and they were good in civil cases. So I used to meet them and I used to fancy them, I used to follow them and used to have inspiration from them. Mr. Abrar, Mr. Dingumal, and in criminal cases, Mr. Zafar Shah's GM Shah, Zafar Shah's uncle, GM Shah. He also used to sit in Bank of India building, that is Courtview. So I got inspiration from this. Then there was Mr. S.A. Nusrat, he later became Judge of Supreme Court and then Election Commissioner also in the election. So these were the persons whom I tried to follow. And then I you see, tried to put in whatever possibility I could put. I devoted my time, although I was young. Although I had recently married, yet I used to sit in my office up to 11 o'clock. So,
That's a lot of dedication.
I tried to do it, and thank God I am reaping the harvest of that labor. There is nothing in life except good work, hard work. And then you should have time for your family also. But then, of course, whenever you devote time, do hard work. Sincerely. Try to take your client into confidence. Point out the defects in his case. Frankly, tell him that these are the defects. I will try to overcome these defects. So try to take him into confidence and then you proceed in right address. So this is. Now another question.
Sir, this is the last question. Just one second. Sir, so my last question is, we have seen, like, when attorneys and lawyers are, like, and advocates, they're, like, given cases. So one of the issues which I'm personally not very clear about, and many people aren't, is whether a lawyer should sympathize or empathize with his clients in order to understand the case better, or in order to, like, gain a better understanding of how to, like, proceed in the court. So in your experience, is that sympathizing or empathizing with the clients, is that a hindrance or an advantage that a lawyer has?
Well, you should always have sympathy towards the person who has engaged you as a client. I will recommend you to read a book. It is Anatomy of a Murder.
Anatomy of
a murder. इसके ऊपर फिल्म भी बनी Hollywood. Anatomy of a Murder. You will know everything. A lawyer should devote right honestly into the case, should sympathize with his client, but not identify with him. You will assist the court as an officer of court on behalf of your client. You have every sympathy with your client. You should have every sympathy with your client. But then don't identify yourself with him. Your client is your client. That is, your client is not you. You should sympathize. You should have kindness towards him. You should have sympathy. You should have good attitude. You see, there are my clients who came in earlier days of my practice and they are still going on with me. In one case or the other, they always engage me. They remember. So you should have a sympathy, kindness to your client because he is worried. He is perturbed. He is rather facing disappointment. So you should sympathize with him, but don't identify with him. If he loses, he loses. He loses. You tried your best. You should try your best. But if he loses, he loses. You will not take it to heart. Case हार गया मैं तो हैं? No, it is not necessary. Always don't identify yourself. Appear in court as the officer of court to assist the court to the best of your ability, to the best of your knowledge, to the best of your education, and try to sympathize with your client because he has engaged you with the hope that you will do something for him. Okay? So this is it. So should I, Rahul, chai by the?
So there is